In this tutorial, we discuss various modes of acquiring immovable property. We all know that in a country governed by rule of law, even acquisition of property shall be in accordance with law only. In India, the following are the various modes which are recognized to acquire an immovable property. Now let us turn to those methods through which one can acquire an immovable property. The first, acquiring an immovable property by way of a sale. Sale refers to a transfer of ownership in an immovable property. Sale is one such mode. In order to acquire it, it shall be registered. If the value of property exceeds rupees 100, and it must be registered. As I told you, sale means a complete transfer of ownership, and there are two persons called buyer and seller. And next, another mode of acquiring property is, as I told you, this is purchasing a property by way of a sale. Next, another is exchange. Exchange refers to, unlike in sale where money is paid in lieu of getting an immovable property, in case of exchange, the property can be exchanged with another property. It can be movable or immovable. And next, in case of immovable properties exchange, it must be registered if the value exceeds rupees 100. Thus, in exchange, we see here one property is exchanged with another property. Now, coming to the gift. Gift is a transfer of property voluntarily and without consideration. Gift of an immovable property, even if of rupees 1 rupee value, it shall be registered and attested. It's not mere registration, it must be attested as well. Another important thing with gift is the donee must accept the gift while donor is competent to convey the property. Otherwise, it cannot be a valid gift. And next, another mode of acquiring property in India is hiba. Hiba is applicable to all religions, is not correct. Hiba is applicable only to Muslim law. Under hiba, unlike under a regular gift where it must be registered and in writing and attested, under hiba it can be oral also. The only condition is it must be accepted by a donee. Thus, having regard to the peculiarity and uniqueness of Muslim law, the concept of giving hiba is recognized under Indian law as well. Only thing is that it applies to Muslims. And next, coming to the acquisition of property by way of a mortgage. We have varieties of mortgage. Primarily, mortgage is meant for securing a debt or loan by transferring an interest in the immovable property. But in case of mortgage by conditional sale, if the mortgagor did not pay the money, that is debt, within the time fixed, there can be a condition that non-payment of money within a prescribed time result in mortgagee as a owner of the property. Thus, through mortgage also, if this kind of condition is prescribed under the contract of mortgage, a person can become a owner, an absolute ownership can be given to him. This is one mode. And next, coming to the section 25 clause 1 of Contract Act, which says a person can convey property by way of a registered instrument in writing between the near relatives who have a love and between near relatives with whom they have a natural love and affection. We must maintain a distinction between gift dealt under our TP Act and property transferred by way of near relatives by way of a natural love and due to natural love and affection. Whereas a gift can be made to any person whatsoever, whereas 25 clause 1 says it must be between near relatives due to natural love and affection. That is the primary difference between both. Now coming to another mode of acquisition of property, that is succession. If any person dies without executing a will, if he has any property, that property will be inherited basing on the succession laws of the each community. by the legal heirs. Thus, being a legal heir of some person, in the absence of any will also, a person can acquire his ancestors' property. This is one method. We have Hindu succession law, Muslim succession law, Christian succession law to this effect. Now coming to the next issue, another mode of acquisition is partition. Partition is peculiar and unique to only Hindus. Under Hindus, there is a concept called joint family system and coparcenary. The term coparcenary indicates a person who acquires property right or a property right in a Hindu joint family being its coparcener. This right is acquired by birth by the Hindu. Generally, the partition is a term used to describe separating the portions basing upon the proportionate interest of the coparcener. This is just a description about how people would partition the properties. Next, coming to the will. If any person having a self-acquired property or property which he has exclusive interest, he can definitely execute a will to the extent of his interest. To the extent of his interest. Will can be revoked as many times as he wish. Will need not be registered, but it must be necessarily attested. Thus, a person can acquire a property even by way of a will. And next mode of acquisition can be assignment. Assignment generally refers to a person having absolute ownership over a property. Definitely they can assign their interest or right to somebody. In fact, we have assignment laws in various states. Under assignment law, even state can assign a property, its property, to a landless poor person. The High Court of Andhra Pradesh in one of its judgment held that assignment person to whom property was assigned shall be treated on par with a owner for certain specific purpose. To put it otherwise, assignment is also a one mode of acquisition of property. And finally, adverse possession. Adverse possession means a person is illegally in possession, exceeding a period of 12 years, illegally, but adversely, openly. Openly refers to known to the original owner and against him uninterruptedly or a period of 12 years, he can be called as an absolute owner. Thus, a person can become a owner by way of adverse possession also. Thus, these are the various modes through which a person can acquire property. One final word I would like to mention is that whenever any person claiming that he has a right over an immobile property or a owner of an immobile property, he must specify the means through which he has acquired. That must be one among this. Otherwise, he cannot said to be called as a owner. That's it.